Okay, good afternoon, everybody. This is the first of three lectures that will deliver the balance of the course content for treaty relations. I appreciate everybody's indulgence in allowing me to deliver this content by way of a YouTube video. My preference is clearly to interact with you person to person in the classroom, but obviously that's not possible. So today I'll be talking about modern treaties and comprehensive land claim agreements, which are an integral part of modern treaties. The next two classes next week on Tuesday morning and Thursday morning will deal with Indigenous governance and how that operates within the context of Section 35 of the Constitution. And then the last two classes will be the class presentations in your groups. We've already had some discussion about that online and by way of email exchange. I haven't heard of any problems that are insurmountable with respect to those group presentations, so I expect them to be all sent to me before the final Tuesday of the last week, and then I will distribute them to all the students. I need you all to watch them and to assess them with a grade of 25 for each presentation. I'll do the same thing, and together your grades and my grades will comprise the total of, I think it's 30% of the final grade. So we'll take care of that in more detail next week. So again, I'm going to give today's lecture on modern treaties. It's going to incorporate a PowerPoint, so I'll share that PowerPoint with you, and then you'll see me in the top right-hand corner of your screen giving you the lecture relative to each slide as we progress through it. Obviously I've posted this video now, so you're watching it. So after you've watched the video, then I will send you a Google form that simply asks you to confirm that you've done the readings and watched the video. And if you've done that, then you'll get a 10 out of 10 for participation. I think that's fair because I can't interact with you to assess additional marks, as I usually do. And for those of you who may have some difficulty with your internet connection, if you live out of town or what have you, I just need you to confirm that you've done the readings and watched, or I'm sorry, and looked at the PowerPoints, and that will also get you a 10 out of 10. So again, that'll be a Google form that I send you after this lecture. All right, so let me pull up the PowerPoint with respect to the lecture. I need to share it. So, all right, so here it is. So again, you should have the PowerPoint on your screen, and then I'll be in the top right-hand corner, and I'll be giving you the lecture relative to what you see. Again, we're talking about modern treaties, and they're also referred to as comprehensive land claim agreements, but in real terms, modern treaties include details and provisions dealing with land claims. Again, the honor of the Crown is certainly at stake when it comes to implementing modern treaties. We've seen that in numerous cases at the Supreme Court that re-emphasize the honor of the Crown. So this is a relatively well-established and fairly old principle that's at stake when dealing with Indigenous issues and the Crown, most particularly the federal Crown, but often the provincial Crown as well. Honor of the Crown requires that the Crown and all its departments and agencies act with honor, integrity, and fairness. So those are elements that we've seen, for instance, in the Delmouth decision, reiterated again in cases like Haida Nation. Comprehensive land claim agreements, which are in fact embodied in modern treaties, are implemented by way of legislation. That's really important to keep in mind because it is a federal statute in which the terms of the modern treaties are embedded. Then these modern treaties have the force of law, just like any other statute that the federal government may in fact implement. For instance, the Criminal Code of Canada, is a federal statute. So that's how important it is to see these treaties as statutory provisions. Likewise, modern treaties are recognized and affirmed under Section 35 of the Constitution. And that's important to keep in mind. If you read the terms of Section 35, it says in that section that all existing treaty and Aboriginal rights are recognized and affirmed by the Constitution. But the Supreme Court has made it very clear that modern treaties entered into after 1982, when the Constitution was enacted, continue to be recognized, even though they weren't in place in 1982 and therefore were not technically existing. So existing in that section simply means that that the treaties are recognized, and they're existing in that they haven't been rescinded or extinguished as a function of federal legislation designed for that purpose. The first negotiation for a modern treaty, and we've talked about this before, was the James Bay Northern Quebec Agreement between the province of Quebec and the Cree, which was the indigenous peoples in northern Quebec, and the Inuit, which likewise are indigenous peoples who live in the Arctic Circle. So those were the two indigenous groups that negotiated this agreement with the province of Quebec. The treaty was not mandated by the federal government, and we've also mentioned this in that to some degree the treaty can be challenged in that it's not constitutional because treaties are required to be entered into by the federal government, and as we've mentioned a number of times, that's a function of the Royal Proclamation of 1763. But having said that, no one, including the federal government, has ever questioned the constitutionality of this particular agreement, and they wouldn't want to, particularly in the 1970s when the independence of Quebec was a very live issue. So the federal government did not want to upset the cart in that regard. So again, even though it's now it's now 45 years since this treaty was put in place, it's really never been challenged as to its validity. Negotiation for the treaty came about as a function of litigation over what was proposed to be an incredibly large development in northern Quebec that was going to be and has become the James Bay hydroelectric plant. So worth billions of dollars in today's monies. The negotiations before the litigation that went on between Quebec and the Cree and the Inuit failed. Robert Bourassa, who was the premier of Quebec at the time, quite honestly didn't think that he needed to enter into a lot of negotiations to put the hydroelectric dam in place and plant into place. He just did not consider the indigenous rights to be that important. But over the course of a relatively short period of time, he found out, in fact, that indigenous peoples did very much have a right to be consulted on something of this magnitude, and so he changed his mind. And that was a political decision as much as it was a legal decision. So as a result of that, the Cree began legal proceedings again, and the Inuit against the Quebec government for failure to consult prior to commencing the project. And after a 6-month hearing in the Quebec Superior Court, the court found, in fact, that the Cree and the Inuit peoples did indeed have Aboriginal rights over their territory, and those rights had been there since time immemorial. And as you can appreciate, of course, in order for the Superior Court in Quebec to come to that decision, again, extensive historical evidence would have been part of that hearing process. That particular decision was overturned on appeal by the Quebec Court of Appeal, right? So they, in fact, found that there wasn't, inherent rights from time immemorial, but that decision then was given leave to appeal to the Supreme Court of Canada, right? And so, both parties recognized in going forward that instead of actually, having this entire matter heard on appeal to the Supreme Court, that it would be in everybody's best interest that the appeal route be circumscribed by negotiating a settlement without further recourse to litigation. After James Bay, the next significant comprehensive land claim and modern treaty was found in what's called the Nunavut Land Claims Agreement, which is really seen as an incredibly robust example of self-government and land tenure rights in a modern treaty. And that's incredibly important because modern treaties primarily do provide for not only the land rights that include an ownership interest, which, as you know, is a much different approach than the federal government has taken to historical treaties, all those treaties leading up to 1975, including Robinson-Huron, Robinson-Superior, and the 11 member treaties. None of those, what are considered historic treaties, have land tenure rights. So Indigenous peoples in these treaties, particularly those who now find themselves on reserves, have only possessory rights to the lands. So the modern treaties, very importantly, provided Indigenous peoples with the right to actually own the lands. So that's a really big change, and one that has only really been put in place over the course of the last 40-odd years. But in 1999, the Northwest Territories was divided into two territories, creating a third territory known as Nunavut. So that was incredibly important because that is largely an Indigenous territory. 80% of the population in Nunavut is in fact Indigenous, being primarily Inuit. It allowed for, again, fee simple, which is an English concept of land ownership, over 350,000 square kilometers of land. The federal government also has contributed over the course of 14 years. This has now been fully paid at this point, compensation in the order of $1.17 billion to assist essentially with the establishment of the territory. And most notably, what this modern treaty did is created a territory with its own government. And we're going to talk more about the government structure of Nunavut next week when we talk about self-government within the context of Indigenous issues. There are various steps in a comprehensive land claims process. They're quite complex, but they flow in a linear fashion, leading from negotiations to the completion of the agreement. So it does make sense. You can find all of these steps set out in a great deal of detail in the Government of Canada's website dealing with modern treaties. The process begins when an Indigenous community submits a statement of claim. Statements of claim aren't the same as statements of claim in civil actions in the superior courts. They're just called statements of claim, which are a claim to the federal government to commence the process of creating a modern treaty. So the statement of claim, along with all of its supporting materials, assert rights to the land that is to become the modern treaty itself. The federal government will accept the claim, again, if the community can successfully confirm that it's had governance over the territory since time immemorial, and it has continued to be what's considered to be an organized society to the exclusion of other organized societies. So again, as I mentioned a few minutes ago, this would involve a tremendous amount of historical material put in place by historians. Again, remember that history is not necessarily objective. It is in fact quite subjective. But in the case of a statement of claim for a modern treaty, you're only really going to have the historians that are hired by the Indigenous group to put their position forward. The community, in establishing its occupation, basically has to show that it is an established historical fact, that they were there at the time of European sovereignty, so at the time of contact, which again is the same test that all Indigenous groups have to put in place when they are protecting their rights if those rights are being questioned or contested by somebody else, most particularly a government body. There has to be some current use as well, so the historical use has to run from time immemorial up to the time, in fact, the statement of claim is submitted. So there has to be a current use and occupancy of those lands for traditional purposes, which is hunting, trapping, fishing, and what have you. It has to be demonstrated to take place from occupation, basically, or contact, up to and including the time the claim is asserted. The federal government, always requires as well that, and again, this is relative to the Section 35 protection of a modern treaty, that Indigenous title and those rights have not been extinguished right? And or have not been dealt with in another treaty. So modern treaties only deal with lands and territories that are basically untouched by the treaty process. As you know, as we talked about last week, if there is a treaty in place and there's an issue involving the treaty, then that takes us to the specific land claims process for treaty interpretation and litigation. So specific claims deal with existing treaties. Modern treaties claims deal with territories that do not have existing treaties in place. So once an Indigenous claim is accepted, the federal government then brings into the process the relevant provincial government in which the modern treaty is being asserted. So obviously if it's in Ontario, it's the Ontario government. As you can appreciate, most of these again take place in the province of British Columbia, which didn't recognize Indigenous claims to treaties in the historic process prior to 1975. So most modern treaties are within the province of British Columbia, and of course, again, Nunavut, which was a tremendous landmass for the purposes of a modern treaty. There are some other small territories, again, in northern Quebec and in the Maritimes. It's important to note that while the federal government will negotiate with any Indigenous community regarding a claim, in practice, treaty negotiations have only extended to First Nations and Inuit communities. So, in fact, there are no comprehensive land claim agreements with Métis communities. Right? So that's important to keep in mind. Here's a video for you on modern treaties and the law. I'm not going to play the video as a function of this lecture. You are certainly welcome to watch these videos on your own time. And as you can see, I've embedded the treaty into the PowerPoint. So you just have to click on to the YouTube video in the PowerPoint slide itself. So that's totally up to you. I'd encourage you to all watch this. It's incredibly interesting and comprehensive, and it will certainly add to your knowledge of modern treaties. Okay, so back to the process. So once the parties agree to commence negotiating, then an MOU or a memorandum of understanding is signed between the parties, basically signifying the commitment of the parties to undertake negotiations. So there's actually, it's a formal contract basically between the Indigenous group seeking the modern treaty and the comprehensive land claim with the federal government and the provincial government, basically saying we are now going to negotiate this treaty. The first stage of negotiations involves coming to what's called a framework agreement, which just makes sense. So this is simply an outline of what the future agreement is going to contain. So this would set out the various chapters or topics in the contract or agreement going forward. So it's a blueprint to some degree as to what's going to follow with respect to reaching an agreement. It will also have deadlines so that the treaty process does not drag on forever, kind of thing. The negotiations leading to an agreement are very complex, and obviously the negotiations themselves comprise the most lengthy stage of the treaty process. Once finalized, the agreement in principle usually contains all the essential components of what is to become the final agreement. And obviously all parties must ratify, which simply means all parties must consent to the final agreement. And then after the terms have been finalized, then as mentioned before, the federal government will pass legislation giving the agreement the status of a federal statute. After the agreement is put in place, right, and the statute's in place, a final agreement implementation plan is also negotiated by the parties, right? This is obviously part of the overall negotiations of it. It is in fact attached as an appendix to the final agreement. And so again, this is a roadmap as to how the agreement is to be put in place after it's actually been negotiated and finalized. Most particularly, it sets out who will be responsible for the implementation of the various terms of what in fact is a contract. Annual reports are generated every year that reviews the activities and what is involved in the implementation process. And 5-year reviews are used to basically provide a detailed analysis on essentially how well have the parties done in living up to the terms of this treaty. For the purposes of this process, the government has put in place this particular document. It's called the Federal Framework for the Management of Modern Treaties. It's an implementation management framework. Right? That's a kind of a long title for basically saying, here is a document that says how the treaty is to be implemented. It is intent of this framework to strengthen the management of modern treaty implementation. Clearly it is the intent of the federal government, the relevant provincial government, and the Indigenous group involved in the modern treaty that it is treated with respect that it deserves, and it's also treated with legality that it deserves. It helps federal officials to fulfill modern treaty responsibilities in what's considered to be a coordinated, consistent, and timely manner by doing the following: improving information sharing between the parties, improving oversight, clarifying accountabilities and responsibilities, facilitating timely and efficient decision-making. And since the inception in 1973 to 75 for the James Bay Agreement, there have been 24 modern treaties negotiated. So in the last 40 to 45 years, resulting in Indigenous claims being incorporated into treaties over 40% of Canada's landmass. So that's a great amount of space. The largest, or one of the largest chunks of that, of course, being Nunavut, and then a great deal of landmass in British Columbia and northern Quebec and other areas where modern treaties are there to be negotiated. Implementation plans for most agreements involve 100 to 200 obligations for the parties, again, to be followed up with, in a very serious fashion once the agreement is put in place by statute. And many agreements basically have the federal government being responsible for over half of those 100 to 200 obligations. And the majority of those are continuing obligations. So once the agreement is entered into, the parties, certainly the federal government doesn't just get to, basically say that's the agreement, we're finished here. Both the federal government and provincial governments have ongoing obligations, right? Most specifically, subjects included in these agreements include the following: title and management of lands, again, ownership, fee simple, incredibly important. Wildlife and resource management, parks and conservation areas, environmental reviews, including monitoring processes for land and water management, mining, heritage resources, economic development, government contracting, procurement, taxation and capital transfers, public sector employment, which obviously is important with respect to employment of Indigenous peoples to work for their own governance, agreement implementation processes, which we've already discussed, and dispute resolution mechanisms, which we'll also discuss in some detail. So again, modern treaties provide for self-government agreements. So this allows Indigenous government structures to be put in place with new jurisdictional and programming arrangements for things to cover how those who live within the territory of the modern treaty, how they live with respect to their health care, education, social services, and infrastructure matters. So as you can see, this very much mirrors what all governments do for the residents within their boundaries. Because the implementation of modern treaties is complex, again, from time to time, disagreements can arise with respect to the obligations for implementation. So in that regard, again, modern treaties contain, embedded in the wording of the treaties themselves, a guide for the management of dispute resolutions. And this obviously is, again, an important part of a treaty to make sure that when problems arise, there are systems and mechanisms put in place to resolve whatever those problems may well be. So we have a dispute resolution process. And this is meant, of course, to increase transparency and credibility through the settlement of these disputes. So, there are a wide range of processes for resolving disputes. They range from consensual negotiations to what are considered to be adjudicative. Adjudicative means essentially a court-like process where the parties adjudicate their issues before somebody who sits and hears them. And we can start from the beginning where there's very little doubt that a resolution to any dispute is hopefully best resolved as a negotiation between the parties themselves without bringing into the process third parties. So hopefully that can take place. If negotiations by way of that conciliatory kind of process doesn't happen, then we move to, in fact, bringing into the picture what are considered to be neutral third parties to assist. But again, when we go from consensual party-to-party negotiation to third parties, at each level that we bring in a third party, the process becomes more complex and more formal. The government of Canada takes a position that a staged approach is preferred, stage being, let's start with the simplest process, which are informal discussions, and move that to a facilitated negotiation. And then lastly, if necessary, to an arbitration, which is very much like a court process. And we'll discuss that. So the majority of treaties with these processes, certainly require them to be voluntary. So the parties have to consent to whatever process is going to be used, as it goes through, the informal process to, whatever more formal issue of adjudication is going to be used. So the stage one are the informal discussions, and keep in mind that these kind of dispute resolution mechanisms are not just those used for these kind of disputes, the issues in modern treaties. These are mechanisms that are in place for all kinds of dispute resolutions, which attempt to basically resolve matters without having recourse to the courts. So it's not just for modern treaties that these kind of stages are put in place, but they certainly do apply in this context. So the first stage, again, is informal discussions. So in all cases, the parties to modern treaties have implementation committees put in place. So these are committees, both from the governmental point of view and the Indigenous point of view, and they come together to, have discussions to hopefully come to a resolution of issues. So obviously these committees play a crucial role in dispute resolution. They basically address issues and differences of opinion, and they deal with, how things can be implemented and discussed. They also include forums for the parties to come together, and they can have experts come and give them information to speak on the matters in dispute. So clearly, you would have experts come in to provide opinions. Say, for instance, if it deals with some kind of resource extraction in the territory, and how that can best be handled and handled properly, most particularly for the benefit of the Indigenous peoples within their territories. So if the negotiations, including having experts come in, doesn't work out between the parties, so the informality of those negotiations don't come up with a resolution, then you move to what's called stage two, which are considered to be assisted negotiations. So this is where basically we have somebody, a neutral third party, who will come in, and it's called conciliation or mediation. So the parties come before a neutral third party and basically enter into, again, further negotiations. The third party can be somebody who doesn't have any particular expertise with respect to treaty rights, but more likely than not, they do. So it's called a facilitated mediation, where somebody with some real expertise and who's likely done this before, or certainly has, knowledge in the implementation of treaties and the issues revolving around treaties, so they can bring their own knowledge to the table when they try to assist the parties to come up with an agreement. So it's important to remember that mediation isn't a process where somebody tries to impose their opinion. They're there to facilitate the parties arriving at a resolution themselves. So what they do is they bring an objective viewpoint to the dispute for the parties to take into consideration. Having said that, is if the mediation route doesn't come to resolution, so the parties still can't negotiate an answer to their problems, then stage 3 is arbitration. Right, so this decision whether to arbitrate occurs at stage 3, and this is very much a formal discussion where negotiation has failed. And so most modern treaties provide that the parties can submit their issues to arbitration, so that'll be contained in an appendix to the agreement itself. And what happens is that the appointment of an arbitrator and the rules that the arbitrator will put in place are going to be found in the treaty document itself. And it sets out pretty much its own in-house adjudication system for this rather formal resolution to issues. It's a significantly different than negotiation or mediation because it's going to be, to a great degree, a binding process where the arbitrator, in fact, hears the arguments from both parties, right, put forward, usually with lawyers. So now we're getting very, very close to a court process, with the exception, of course, that the arbitrator is appointed by the parties from a list of arbitrators that they agree to. It's not before a federally appointed judge in the Superior Court, for instance. So it's going to be an arbitrator that is appointed. The arbitrator is going to follow the rules that have already been put in place in the treaty document itself, and then we'll hear arguments from both parties, and then the arbitrator, very much like a judge, will make a decision that is binding upon the parties. So the parties appreciate that after they've argued their positions, they're going to have to live with the decision made by the arbitrator. There are 2 instances where the federal government will not submit to the arbitration process. So these are 2 instances where the federal government basically indicates that it's maintaining its own discretion, that it's not being shared. So the first one are funding matters. So where the federal government won't arbitrate issues dealing with the funding of how it funds agreements and all these kind of matters, what have you. So if the issue is one dealing with funding, then it's going to have to be determined through negotiations between the government and the Indigenous peoples. It's not going to be put to arbitration, so that again the federal government would not put its funding decisions in the hands of a third party. Okay. The government will not agree to binding arbitration in that regard because it deals with a loss of its policy discretion, right? And so that's something that it deals with on its own and deals with through intergovernmental transfer payments, again, which are federal policy decisions. The second instance is public law issues, which public law is things like constitutional law and principles of contract law, tort law, tax law, which are purely questions of law. So, if that is what's at issue, the government again will not put that into the hands of an arbitrator to make a binding decision. The federal government keeps that decision-making and policy-making process within its own house, so to speak, right? And lastly, again, here is another YouTube, again, for you to watch on your own time. It's informative. It's slightly over an hour long, so you have to set yourself aside some time to watch it. And again, it's embedded into the YouTube itself, so you're welcome to watch it, on your own. Right. So, having said that, that's the end of the video. So again, please watch this on your own time. I'm going to send you a Google form after you watch this lecture to basically confirm that you've done so. And when you send me back the Google form, you get a 10 out of 10 for participation with this lecture. So again, I thank you for your indulgence in allowing me to present the content this way. And next week, we'll move on to the next lecture on Indigenous rights and self-governance. Thank you.